Good morning, everyone. Welcome to day 3 session of International Faculty Development Program. Good morning, sir. Our guest speaker is with us. Let me start by introducing our guest speaker, Dr. Tapan. Dr. Tapan Chakraborty Dr. Tapan Chakraborty is retired from the Bureau of Police Research and Development, Ministry of Home Affairs, Government of India as DIG. His key contributions include research and publications by policing system, gender justice, correctional administration, human rights, internal security, and related issues. He has authored over 30 books, either edited or self-written or co-authored with a noted expert as on criminology, namely John Winterdine, senior professor of Mount Royal University, Canada, on different aspects of policy, homeland security, and related issues. Besides other awards, he is a recipient of Govind Vallabh Pant Award for writing a book titled सामुदायिक पुलिस व्यवस्था in Hindi in the year 2002. Also, Government of India recognized his exemplary services by bestowing on him the President's Police Medal for meritorious services on the eve of Independence Day in the year 2020. Dr. Chakraborty has guided PhD students of criminology from different universities like Jawaharlal Nehru University, Delhi University, London School of Economics, Monash University, Australia, Madras University, Sagar University, and many other universities also. He has been a regular guest faculty in reputed universities, institutes, government organizations, and has delivered lectures in various national and international conferences. Dr. Chakraborty has received recognitions from senior police officers like Dr. Kiran Bedi, IPS, former Lieutenant, Lieutenant Governor of Puducherry, Sri Shankar, Senior IPS retired, and many other officers also. Dr. Chakraborty is the Executive Director of Foundation for Police Research and editor of Corps Today International, a journal of international repute. He has 2 times jury member for Outstanding Security Performance Award. Over to you, sir. We welcome you all. Sir, can you please unmute yourself? You are not audible. Tapan sir, can you please unmute yourself as you are not audible to us?
सर माइक का ऑप्शन आ रहा होगा आपकी स्क्रीन पे, उस पर एक बार क्लिक कर दीजिए, टैप कर दीजिए। जहाँ रेड कलर का ऑप्शन होगा कॉल डिस्कनेक्ट करने का, उसके साइड में माइक बना होगा, उस पर एक बार टैप कर दीजिए। नहीं नहीं हुआ है सर, अभी ऑप्शन ऑफ ही है। एक बार स्क्रीन पे टैप करने के बाद माइक पे टैप कीजिए, माइक का ऑप्शन आ रहा होगा। Sorry for the inconvenience. We'll begin in 2 minutes.
Sorry for the interruption. We are facing some technical issue and we are going to start in 5 minutes.
ओ आ गया नहीं मेरा। अभी और अभी सुनाई दे रहे हैं?
Yes, sir, definitely. You are very much audible.
ओके 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 ओके, थैंक यू, सॉरी।
कोई बात नहीं सर. It was some technical error. Now sir is going to start. Over to you, sir.
Okay, thank you. Sorry for interruption and some problems I have faced. Okay, at the outset, I thanks all the esteemed participants and especially Komal Yadav and Prerna and all the respected members of the university to give me a chance to give a lecture on cybercrime. My topic is the wording of cybercrime the correct way. It means that cybercrimes, what is cybercrime, and what is the future of cybercrime, what is the scope of research in our country on this cybercrime. I'll just go through, and I hope this lecture will help you in theoretical perspective way. So I'll point out what are the different types of cyber crimes, how we can prevent, and how you can be a safe person from to avoid cyber crime, and what is the scope of research in our country, and the trends of cyber crime in our country. So cybercrime basically is a computer crime. When it was started, it was termed as a computer crime. But gradually it has become a cybercrime all over the world. And the cybercrime basically is related to the computer network or a networked device. Criminal activity is done in the cybercrime in the computer itself. Most, but not at all, cybercrime is committed by cyber criminals or hackers who want to make money. Cybercrime is carried out by individuals or organizations. Some cyber criminals are organized, use advanced techniques, and are highly technically skilled, and others are novice hackers. Rarely, cybercrime aims to damage computers for reasons other than profit. This could be a political or personal. Now, what are the different types of cybercrimes? There are a number of types of cybercrimes. Say emails and internet frauding. Next, identity fraud, where personal information is stolen and used. Next, theft of financial or card payment data. Then cyber extortion. It is demanding money to prevent or threatened attack. Resources ransomware attack. This is a type of cyber extortion. Cryptojacking, where hackers are using cryptocurrency. And next one is cyber espionage, where hackers access government or company data. Most cyber crimes falls under two main categories: criminal activity and targets. Number two, criminal activity that uses computer to commit other crimes. Cybercrime that targets computers often involves virus and other types of malware. Cyber criminals may infect computers with virus and malware to damage a device or stop them working. They may also use malware to delete or steal data. Cybercrime that stops users using a machine or network or prevents a business providing a software service to its customers is called a denial of service attack. It means DOS attack. Cybercrime that uses computers to commit other crimes may involve using computers or networks to spread malware, illegal information, or illegal images. Sometimes cyber criminals conduct categories of cyber crimes at once. They may target computers with virus first, then use them to spread malware to other mechanics or machines or throughout a network. So cyber criminals may also what is known as a disturbed denial of service attack, which is much more dangerous than denial of service attack. This is similar of DOS attack, but cyber criminals use numerous compromised computers to carry it out. The European Convention of Cybercrime, where United Nations also signed, has cast a wide net, and there are numerous malicious computer related crimes. For example, illegal interceptions or illegal intercepting or stealing data, interfering with system in a way that compromise a network, infringing copyright, illegal gambling, selling illegal items online, soliciting, producing, or processing child pornography. Examples of, now we can see there's some examples of cyber crimes. In all over world, there are big cybercrime activities. Some of the well-known examples I want to cite here. Malware attacks. A malware attack is where a computer system or network is infected with a computer virus or other types of malware. So a computer compromised by malware could be used by cyber criminals. Several process. These includes stealing of confidential data, using device or step or stop them working. A famous example of malware data attack was WannaCity or WannaCry ransom war attack, a global cybercrime committed in May 2017, when WannaCry ransomware attack hit 230,000 computers were affected across 150 countries. Worldwide, the cybercrime was estimated to have caused 4 billion financial loss. Next, come to phishing. A phishing campaign is when spam emails or other forms of communication are sent on masses with the intention of tricking recipients into doing something that undermines their security or the security of the organization they work for. Phishing campaign messages may contain infected attachment or links to malicious site, or they may ask the receiver to respond with confidential information. A famous example of a phishing scam from 2018 was one which took place over the World Cup. The World Cup phishing scam involves emails that were sent to football fans. These spam emails try to enrich fans with fake free trips to Moscow, where the World Cup was being hosted. People who opened and clicked on the links containing these emails had their personal data stolen. Another phishing campaign, as known as spear phishing, these are targeted phishing campaigns which try to trick specific individuals into jeopardizing the security of organization they work for. Unlike mass phishing campaigns, which are very general in style, spear phishing messages are typically crafted to look like messages from a trusted sources. As for example, they are made to look like they have come from the CEO or IT managers. They may not contain any visual clues that are fake. So now the distributed DOS attack. Distributed DOS attack are a type of cybercrime attack that cyber criminals use to bring down a system or network, sometimes connected interact of things or IoT, which is called as IoT devices, are used to launch DDoS attack. Distributed attack overwhelms a system by using one of the standard communication protocol it uses to spam the system with connection requests. Cyber criminals who are carrying out cyber extortion may use the threat of disturbed denial of service attack to demand money. Alternatively, a DDoS may be used as a distraction tactic, which other type of cyber crimes takes place. A famous example of this type of attack was held in 2017 when UK National Lottery website was totally smashed. This brought the lottery's website and mobile app offline, preventing UK citizens from playing this lottery app. So, In India, now I am just going through the trend of cyber crime in our country. Basically, the only organization of Government of India is the National Crime Record Bureau, which is under Ministry of Home Affairs, who is the responsible for compiling the data related to crimes all over the country. So cyber crimes related cases are also interpreted and tabulated by NCRB. So it was found that the country registered 44,735 occurrences of cyber crimes in 2019 compared to 27,248 in 2018. According to NCRB, there were 4,047 incidents of online banking fraud, 1,093 OTP frauds, 1,194 credit debit card frauds, and 2,160 cases of ATM frauds detected in 2020. There were also 578 examples of fake news on social media, 972 occurrences of cyber stalking or bullying of women and children, 149 fake profile incidents, and 98 cases of data theft. The maximum 60.2% of cyber crimes reported in 2020 were for fraud, that is 30,140 out of 50,035 instances. Sexual exploitation accounted for 6.6%, that is 3,293 incidents, and extortion accounted for 4.9%, that is 2,440 cases. Uttar Pradesh has the most cyber crime instances with 11,097, followed by Karnataka 10,741, Maharashtra 5,496, Telangana 5,024, and Assam 3,530. 738 of the 842 internet offenses involved the publication or transmission of content portraying children in sexually explicit acts. In compared to the previous year, the NCRB 2020 data shows a substantial increase, over 400% in cyber crimes reported under the Information Technology Act committed against children. In 2019, there were 164 incidents of cyber crime against minors recorded, compared to 117 cases in 2018 and 78 cases in 2017. Even while the number of cyber crime cases involving minors in 2020 is expected to remain low, the increase from 2019 is concerning. The NCRB has started collecting cases in 2013. From 2013, you see, in 2013, The total number of cases was 5,693 only, whereas it has increased abruptly in 2020 up to 50,035. In 2019, it was 44,735. It means it is an increase of 11.8%. The reason behind this increase is to a great extent the COVID pandemic, situation of all over the country and in our country. The people were confined to their home and they uses their computer online to study online, and that this was one of the major reason for increase of cyber crime cases. There is no information to determine the magnitude of the epidemic containment measures, influence on online abuse and exploitation of children, school closures, and children's increased exposure to the internet realm may have had major consequences for the heightened online hazards they faced. However, no definite data is available in the public domain to determine the amount of children using the internet for schooling and other activities in India, particularly during the pandemic situation. Throughout the epidemic and lockdown, people were obliged to utilize the internet for educational, entertainment, professional, and social purposes. Working women began using computers, smartphones, and the internet to work from home. Women who are still in school have been compelled to utilize the internet for online study and other educational purposes. The rate of cybercrime against women began to climb this time period since the majority of women are utilizing social media, websites, and one or more online platforms for educational, professional, and leisure objectives. Because the entire country was under lockdown, criminals were unable to physically harm the victims. So they began pestering them mentally and emotionally. Some major types of cyber crimes which were mostly affected during pandemic situations are cyber stalking, sextortion, cyber hacking, cyber bullying, pornography, and cyber sex trafficking. Cyber stalking includes, among other things, connecting or attempting to engage with the victims via social networking site or phone conversations, despite her obvious apathy, writing messages, often threatening also, on the victim's page and persistently pestering the victims with email message or phone calls. Then sextortion is the most commonly perpetrated cybercrime affecting women. By blackmailing their victims into releasing their private pictures or altered images, the crooks began extorting money or sexually favors from them. In response to the epidemic's dissatisfaction, offenders sought sexual video conferencing or letters from women by frightening them. Their lack of financial resources empowered them to threaten people with their altered images in order to extort money. Then cyber hacking. During the pandemic, people began reading news online. There has been an upsurge in the quantity of false news and information reports. After clicking on malware URLs, the women's phone were infected with malware, which grabbed all of their personal information, enabled the microphone and camera, and recorded intimate photographs and videos. The data and photographs are then used by criminals to perform sextortion and other crimes. Then cyberbullying. This includes making false, misleading, and abusive statements about the victims on social networking sites and demanding payments to have them removed, leaving hurtful comments on the victim's posts, exchanging morphed or private pictures of the victims without her consent, and threatening the victims with rape and death, among other things. Phishing. Phishing to make money during the lockdown. Criminals send bogus email messages with a link to a specific web page in the hopes of tricking the victim into entering entering personal information such as bank payment information, contact information, and passcodes, or infecting the victim's device with harmful virus as soon as the link is clicked. These emails and text appears to be authentic. The criminals then use the victim's bank account and other personal information to make suspicious transfer from the victim's account to their own account. Pornography. Perpetrators participated in online sexual assault of women throughout the pandemic, morphing the victim's picture and using it for pornographic reason. And lastly, cyber sex trafficking. Unlike sex trafficking, victims of cyber sex trafficking have no direct contact with the abuser during the pandemic time. When a dealer broadcasts films or pictures a victim performing sexual or personal acts from a central location, the footage is subsequently sold on the internet to sexual abuser and consumers by coercing or deceiving or blackmailing women into participating in cyber sex trafficking. The criminals have sexually assaulted them. So, due to these reasons, in pandemic situation, the cases of cybercrime has increased abruptly. So now you have understand, I think, how the horrified this cyber cases and cyber crimes and cyber criminals are. What are the best ways to protect yourself from these cyber crimes and from cyber criminals. Here I'll give you some tips or top tips which you just hear. Number one is keep software and operating system updated. Keeping your software and operating system up to date ensures that you benefit from the latest security patches to protect your computer. Next one, use antivirus software and keep it updated. Using antivirus or a comprehensive internet security solution like Kaspersky Total Security is a smart way to protect your system from attack. Antivirus software allows you to scan, detect, and remove threats before they become a problem. Having this protection in place helps to protect your computer and your data from cybercrime, giving you peace of mind. If you use antivirus software, make sure you keep it updated to get the best level of protection. Next one is use of strong password. Be sure to use strong passwords that people will not guess and do not record them anywhere, or use a reputable password manager to generate strong passwords randomly to make this easier. Next, never open attachments in spam emails. A classic way that computers get infected by malware attacks and forms of cybercrime is via email attachment in spam mails. Never open an attachment from a sender you do not know. Do not click on links in spam emails or untrusted websites. People become victims of cybercrime is by clicking on links in spam emails or their messages or unfamiliar websites. So avoid doing this and stay safe online. Next one is do not give out personal information unless secure. Never give out personal data over the phone or via email unless you are completely sure the line or email is secure. Make certain that you are speaking to the person you think you are or he is known to you. Next remedy is the contact companies directly about the suspicious request. Try to avoid via or third party. If you get asked for data from a company who has called you, hang up, call them back using the number on their official website to ensure you are speaking to them and not a cyber criminals. Ideally, use a different phone because cyber criminals can hold the line open. When you think you have redialed, they can prevent to be from the bank or other organization that you think you are spoken to. Next one is to be mindful of which website URLs you visit. Keep an eye on URLs you are clicking on. Do they look legitimate? Avoid clicking on links with unfamiliar or spammy looking URLs. Last one is to keep an eye on your bank statements. I hope these tips may help you to avoid falling foul of cyber crimes or cyber criminals. However, if all these fails, spotting that you become a victim of cyber crimes quickly is important to intimate the concerned authority. So my advice is to keep an eye on your bank statements and query any unfamiliar transactions with the bank. The bank can investigate whether they are fraudulent or not. So now, what is the future of controlling cyber crimes in our country? In fact, research work is not so much satisfactory till date, but all state and government and private organizations are striving towards getting more and more research work to control the cybercrime, because with the advancement of technology, regularly on constant basis, the crime or criminals activity in computer is also growing. And you see, all criminals or cyber criminals are much more advanced than than others. Than the government itself. So, in our country, Bureau of Police Research and Development has set up a cyber cell to study the problem of cyber security throughout the country. Under that, TOU unit was set up, that is Threat Analytical Unit. And 14C Center. 14C Center means Indian Cybercrime Coordination Center. So, under this TO unit, BPR&D has, Government of India has sanctioned 6.6 crores to different Indian Institute of Technologies of different states, management institutes, to study thoroughly on the issue of cyber crimes and cyber criminals. So, although we are also not lagging behind to other countries, we are striving towards, and thorough research is, where government is also felicitating the research activities. So we hope that within a very short time, we can get a very good solution to combat or to control the cyber crime to a great extent. Very recently, you might have seen in the newspaper that government will lead a draft plan for cyber security BIMSTEC. It was published in Hindustan Times. Just read out the news item that India will lead a project to draft a 5-year plan for combating cyber security challenges in members countries of the Bay of Bengal Initiative for multi-sectoral technical and economic cooperation. BIMSTEC. In short form, it is BIMSTEC. I repeat, Bay of Bengal Initiative for multi-sectoral technical and economic cooperation. The announcement came on the last day of a conference organized in the capital, attended by officials from all member countries: Bangladesh, Bhutan, India, Myanmar, Nepal, Sri Lanka, and Thailand. After discussion, it was found that we are facing all the countries, all the member countries, I mean to say the all member countries of BIMSTEC are facing similar problems of cybercrime, fake news, ransomware, etc. Since India has a vast experience in this field, it was decided to take the lead and have identified 7 pillars of cooperation over the next 5 years. So it is a major challenge for our country and the Asian other countries and the member of BIMSTEC to do a thorough and in-depth research on the cyber security and to control to some extent or to a great extent this problem. You see, technological development is a growing. We cannot stop. And side by side, this crime activity is also going on. The trend of crime has totally changed nowadays in all over the country, all over the world. So we have to think with the changing society's attitude, changing society's atmosphere. So things are changing, and researchers and all technological experts are also thinking with the changing scenario of our society. So with this, I want to conclude my lecture. Thank you very much. Hello.
Thank you, sir. Thanks a lot, sir, for such a knowledgeable session on cybercrime. We are grateful for the time and effort you took to share your thoughts and experiences with us. Your years of research, your depth of understanding of the topic, and your ability to present the subject in such an interesting way produced one of our most memorable lectures. We all thank you on the behalf of all the participants and Team Starex University Gurugram. And this session is very valuable and useful for us in today's world of digitalization. So, sir, I request you please do not leave the meeting as I am going to introduce our second speaker for the morning session of IFDP, Starex University, Gurugram, Professor Dr. Amresh Kumar, Registrar, Starex University, Gurugram.
Thank you. Thank you.
Thanks a lot, sir.
Thanks.
Thank you.
Good morning to all.
Good morning, Registrar, sir.
Good morning and
Yes,
thanks to IFDP team of the Starex University Gurugram.
Please kindly mute yourself.
Let me introduce our Amresh sir, our registrar sir, to all the participants. Professor Dr. Amresh Kumar is presently engaged as a registrar of Starex University, Gurugram, Haryana. His academic excellence includes PhD in physical education, a study of dermatoglyphics in sports 1987, Bachelor of Legislative Law 1992, Jivaji University. He has been a member of International Sports Law Journal 2009. He has been a keynote speaker at the prestigious International Association of Sports Law in various countries like Greece, South Korea, Russia, China, Hague, and Switzerland. He is a fellow ASSR SSER International Sports Law Center, TMC ASSER Institute, The Hague, the Netherlands. He also introduced the UGC add-on career orientation program in physical education, sports law and agent services, sports journalism and electronic media coverage, sports event management and yoga naturopathy. He is also an author of 19 books in sports, physical education, yoga and sports law. Our sir is a great leader. He is very humble, a great lawyer and our role model too. He also guided us to organize this IFDP, and in fact, I would like to say that this IFDP was possible only by the support of our registrar, sir. Registrar, sir, over to you.
Morning, Vaasawa, and good morning to all the teams. A wonderful organization, and I'm appreciating and getting appreciation from various walks of the countries. My topic today, which I will be given, before starting my topic, I just want to let all the participants that this topic is based on a representation or a petition filed before the Parliament Committee of the Parliament of India, where I have submitted that how the judiciary system, how the Indian judiciary system can be improved. And mostly I am thankful to the Prime Minister of India as well as the Government of India that some of this petition has been considered by the government, and I will show you the video after my presentation in the last, that even the Prime Minister of India, in a meeting with the Chief Ministers and Chief Justices of all the states, have announced it, and I'm proud of that. So before starting, I just want to start from my presentation first. I don't want to stick on this project because it has already been introduced by you. So I will just straightway come to my topic. My topic today is need to research the language of law in the higher judiciary in easy and common language of the people and litigants. Since I had been also practicing in the High Court and Supreme Court of India, and with my experience since 1996 onwards as an advocate for whatever span I have devoted in this courts. What I have observed that all the petitions, all the judgments of the high courts, Supreme Court, or maybe say the higher judiciary system, it comes in the language that is in English. And what happens? We in India comprises of 80% of the people, those who are illiterate. As per the census of the Government of India, hardly 20% people are, we can say, literate and very well versed in English. So this petition, which I am coming before the audience, before the participants, this is based on the Department-related Parliamentary Standing Committee on Personal Public Grievances, Law and Justice, which I have faced before the 30 member of parliaments comprising of Lok Sabha, Rajya Sabha, and the chairman of this committee was Shri Bhupendra Singh Yadav. He is now Minister for Small Scale Industrial Ministry. And this was presented on 20th July 2018. So based on this, I have made my presentation that India has got freedom in 1947. Constitution has been enacted in the year 1951. And under the Constitution, Article 343 of 1, the official language of India has been explained or written, that is Devanagari script. But under Article 351, it has also been stated that the English will be the official language of the Indian Constitution for 15 years. And thereafter, in phased manner, it will be removed or it will be improved in the Indian languages, in the Devanagari languages. The Constitution of India, you all know as the law graduates or the law experts, under Article 14 has given the law equalities to all the people of the country. Under Article 22, it makes obligatory to the state to ensure equality before the laws and legal system, which promotes justice on the basis of the equal opportunity to all. But what happened? Even after 75 years of our independence, this year we are celebrating Amrit Mahotsav, Azadi Ka Amrit Mahotsav, 75th celebration of our independence. But according to me, and later on I will also show you on the small video clippings, even as per the Prime Minister of India, it has not been done for the real independence or real constitution for the country. As you know, the language of the court in the higher judiciary is still English. In some of the past judgment, the Honorable Supreme Court has imposed heavy penalty on some of the advocates, some of the litigants for writing petition in Hindi. So this, according to me, is very injustice, very unethical, and against the provisions of the Article 14, which strongly suggests that equality access to the court. In a court, we say that all the people are similar. There is no higher persons, no illiterate, no educated persons. But till date, what I have understood and what I have seen in the courts, especially higher judiciary, some of the judges and some of the senior advocates, they are not for the local language for the people. But you might be knowing that all the judgments, all the petitions which is being petitioned before the court, it is in English. And it is though it may be against some of the judges, some of the senior advocates, that most of the judgments are being rewrite or collections of the previous judgments on the basis of copying some of the things, and only last part, concluding part of the judgments are there. That is also not clear what has been given in the judgments, what relief has been given to the people. So this, according to me, the language of the Supreme Court and a High Court should be enacted in such a manner that it should be the language of the common people. In my first slides, you might be seeing that I have conceptualized the language of the country. It is not it should not be only Hindi, but whatever the state is there, if it is in Gujarat, it should be in Gujarati. If it is Bengal, it should be in Bengali. Because nowadays, the information system, the computerized system has become so fast, so intelligent that any language can be translated through the use of the computer or through the use of even Google Translator in any language. So the thing that the language of the court should be only in English, according to me, it is very unbiased, very much unconstitutional, and it deprives the people of the right of equality. I had petitioned also in one of the case before the Honorable High Court of Madhya Pradesh, where I was working as a research assistant, and then there the students were not allowed to write or read in their own language. The language was only English, and for 25 years it was an English language. So realizing the problem of the students, because that was a University of the Physical Education and Sports, and according to me, most of the sports person or students, they were not well versed in English, but the thing that they were supposed to write or read in English only. So when I petitioned a public interest litigation before the Honorable High Court, which has been also published in the AIR in 1997, MP 43, the court has observed Article 343 provides that official language of the Union shall be Hindi in Devanagari script. The language has to be enforced within 15 years from the date of enforcement of the Constitution. So in the phased manner, when we got independence in 1947, it was decided by the Parliament that initially it will be the English, but slowly it should be, in the phased manner, it should be Hindi or Devanagari will be the Indian language. Though the framer of the Constitution provided the way for interim arrangements of the official language, and they continue for English, as I have already explained to you, for 15 years. However, the period has been extended. And still, after 75 years, you can say, live about 15 years, we are now in our independence era or year of 75th independence. Still, we are not able to surpass these things. Then, in that judgment only, the Honorable High Court has observed or passed, though the India won its independence in 1947 on 15th August, yet we could not overcome the mental slavery till today. I'm quoting till today means even after 75th years of our independence, that it is little 50 years, because that was the time, it was the 50 years when this judgment was passed. It is well known that very little percentage of the Indian population knows English, yet vested interest of the minorities of the people who had advantage of being in higher post on account of the knowledge of English never wanted this article should be enforced, and they have a feeling of superiority on account of the knowledge of English. It is well known that child learns the language of the mother and understand the same. On account of the imposition of the language, English majority have better knowledge, cannot achieve the expected result on account of the failure of the express or write their views in English, with the result there who have knowledge of English yet less intelligent. The court observed the people, those who are having knowledge of English, cannot be said very much intelligent. They are having less intelligence. Even our farmers, our village people, they have got more intelligence than the people those know English. But here the court has observed the people know the English, yes, less intelligent, had become superior to majority of the students or people who have little or no knowledge of the English. So what I want to say, our Indian judiciary should also start some research, some work, that the judgments, the laws which has been written in 1880, when the British was ruling the country, these judgments and laws should be made in easy language of the local people, of the masses. If it is in Maratha, it should be in Marathi. If it is in Tamil Nadu, then it should be Tamil. Gujarat, mein Gujarati hona chahiye. And Hindi, of course, it is known as our national language. We cannot say mother language because mother language is always the regional language. So according to me, this should be one of the part of the research as our today's or IFDP is that the research on the legal judiciary system. So according to me, we have worked under the Indian British law 200 years, and then after independence also 75 years. Some of the institutions of law, some of the universities of law, we all as an experts of the law should start researching or converting the rules or laws of the India country in the local language, in the Hindi. So this is my topic today on which I want to specifically stress. And even before the Parliamentary Standing Committee on 2018, it was one of the suggestions to the Parliamentary Standing Committee to bring the judicial reforms, easy judicial system, and access to all the people, the judicial system, it was there. Though some of the Member of Parliament opposed that, and I don't want to name all, but one of the most popular Member of Parliament, Mr. Subramanian Swamy, he was the one who opposed like anything. You want to change the whole judiciary, which is very fatal. But no, according to me, if the judiciary system is translated, researched in our local language, in our Indian language, in our regional language, or even in our Hindi, it will provide an easy judiciary, easy justice system. In the judgment passed by the Honorable High Court in the year 1987. Law Commission of India has advocated for that, but again, some of the senior judges who were the member of the law commissions, some of the senior advocates who were the member of the law commissions, they have opposed to this. They said, no, the Hindi or the local language cannot be the language of the higher judiciary. But again, as an advocate, what I experienced, a judgment of 50 pages, a judgment of 100 pages in English, no substances in the internal part of the judgments. A poor litigant, a litigant who does not know English, what his advocate, what I have pleaded in the petition, he does not know what I have pleaded for him and what I have pleaded before the honorable courts and what the honorable judges have delivered the judgment, whether it is in his favor or it is in against. He is not able to understand due to the language problem, due to the thing that the judgments, petitions, arguments, and everything is in English. And the people from the Assam or people from the Bengal or Tamil Nadu is not able to understand what has been pleaded for him, what judgment has been granted in his favor or is in against. So according to me, this is one of the very essential part, very needed things for the Indian judiciary. And it is my suggestion that the Parliament of India should enact an enactment that the language of the higher judiciary, we should get rid of the British laws, British rules. Those were framed in 1800s and still following our higher judiciary. In this regard, if you have listened or heard a conference which has been addressed by our Honorable Prime Minister, Shri Narendra Modi ji, this was the conference and seminar for the Chief Justices of all the High Courts, Justices of all the Supreme Court, and Chief Minister of all the states. In this seminar, he has very categorically stressed and shows his intention, his curiosity, his love for the Indian nation or Indian citizens, that the language of the courts, language of the easy access of the justice should be the Indian language. So I just want to have You have 4 minutes more, 4 to 5 minutes to show this video.
That was really a thought-provoking lecture, esteemed Registrar sir. The
Let me
topic
show
of
the video, then
okay.
we can.
न्याय जनता से जुड़ा होना चाहिए, जनता की भाषा में होना चाहिए। जब तक न्याय के आधार को सामान्य मानवी नहीं समझता, उसके लिए न्याय और राजकीय आदेश में बहुत फर्क नहीं होता है। मैं इन दिनों सरकार में एक विषय पे थोड़ा दिमाग खपा रहा हूं। दुनिया के कई देश ऐसे हैं कि जहां कानून बनाते हैं तो एक तो लीगल टर्मिनोलॉजी में कानून होता है, लेकिन उसके साथ एक और कानून का रूप भी रखा जाता है जो लोक भाषा में होता है, सामान्य मानवी की भाषा में होता है, और दोनों मान्य होते हैं। और उसके कारण सामान्य मानवी को कानूनी चीजों को समझने में न्याय के दरवाजे खटखटाने की जरूरत नहीं पड़ती है। हम कोशिश कर रहे हैं कि आने वाले दिनों में हमारे देश में भी कानून एक पूरी तरह लीगल टर्मिनोलॉजी हो, लेकिन साथ साथ वही बात सामान्य व्यक्ति की समझ में आए उस भाषा में, और वो भी दोनों एक साथ असेंबली में या पार्लियामेंट में पारित हो, ताकि आगे चल करके सामान्य मानवी उसके आधार पर अपनी बात रख सकता है। दुनिया के कई देशों में ये परंपरा है। अभी मैंने एक टोली बनाई है, वो उसका अध्ययन कर रही है। साथियों, हमारे देश में आज भी हाई कोर्ट्स और सुप्रीम कोर्ट की सारी कार्यवाही इंग्लिश में होती है, और मुझे अच्छा लगा सीजेआई ने स्वयं ने इस विषय को स्पर्श किया। साथियों, एक बड़ी आबादी को न्यायिक प्रक्रिया से लेकर फैसलों तक को समझना मुश्किल होता है। हमें इस व्यवस्था को सरल और आम जनता के लिए ग्राह्य बनाने की जरूरत है। हमें कोर्ट्स में स्थानीय भाषाओं को प्रोत्साहन देने की जरूरत है। इससे देश के सामान्य नागरिकों का न्याय प्रणाली में भरोसा बढ़ेगा, वो उससे जुड़ा हुआ महसूस करेगा। अब इन समय हम एक कोशिश कर रहे हैं कि टेक्निकल एजुकेशन और मेडिकल एजुकेशन मातृभाषा में क्यों नहीं होना चाहिए। हमारे बच्चे जो बाहर जाते हैं, दुनिया की वो भाषा कोशिश करते हैं पढ़ करके फिर मेडिकल कॉलेज की, तो हम हमारे देश में कर सकते हैं। और मुझे खुशी है कई राज्यों ने मातृभाषा में टेक्निकल एजुकेशन, मेडिकल एजुकेशन के लिए कुछ इनिशिएटिव लिए हैं। तो आगे चल करके उसके कारण गांव का गरीब का बच्चा भी जो भाषा के कारण रुकावटें महसूस करता है, उसके लिए सारे रास्ते खुल जाएंगे। और ये भी तो एक बड़ा न्याय है, ये भी एक सामाजिक न्याय है। सामाजिक न्याय के लिए न्यायपालिका के तराजू तक जाने की जरूरत नहीं होती है। सामाजिक न्याय के लिए कभी भाषा भी बहुत बड़ा कारण बन सकती है। साथियों, एक गंभीर विषय सामान्य आदमी के लिए कानून की पेचीदगियां भी है। 2015 में हमने करीब 1800 ऐसे कानूनों को चिन्हित किया था जो अप्रासंगिक हो चुके थे। इनमें से जो केंद्र के कानून थे, ऐसे 1450 कानूनों को, 1450 कानूनों को हमने खत्म किया। लेकिन राज्यों की तरफ से केवल 75 कानून ही खत्म किए गए। मैं आज सब आदरणीय मुख्यमंत्रीगण यहां बैठे हैं, मैं आपसे बहुत आग्रह करता हूं कि अपने राज्य के नागरिकों के अधिकारों के लिए, उनकी ईज ऑफ लिविंग के लिए आपके यहाँ भी ये कानूनों का इतना बड़ा जाल बना हुआ है, कालबाह्य कानूनों में लोग फंसे पड़े हैं, उन कानूनों को निरस्त करने की दिशा में आप कदम उठाइए, लोग बहुत आशीर्वाद देंगे जी।
Hello.
Hello.
So now we have seen the even government, the Prime Minister has a concern to make a social justice system. Though we all are luminaries of the law, legal fraternity, we studied very voluminous books, mullahs or shirvis or Basu's constitution. But the thing is that if it is not made for the masses, real justice will never be delivered to them. So that is my feeling as a lawyer, as a faculty, as a teacher, that in this way or in this prospects, we have to do the research. हम इंग्लिश भी जानते हैं, हिंदी भी जानते हैं, हमको उन लोगों के लिए कानून ट्रांसलेट करना चाहिए, दैट इज ऑल्सो पार्ट ऑफ रिसर्च. उन लोगों के लिए कानून बनाना चाहिए जो कि आम जनता है. एक बंगाल का आदिवासी, एक झारखंड का आदिवासी, तमिलनाडु के हमारे जो तमिल भाई हैं, तेलुगु जो बोलते हैं, उन लोगों के लिए कानून बनाना चाहिए. और इट इज नॉट डिफिकल्ट to do that. And even the COVID, you might be knowing, एक मेरा दूसरा प्रेयर था अपने पिटीशन में कि आईटी सिस्टम को डेवलप किया जाए. आईटी सिस्टम इन द सेंस कि what as an advocate I plead before the court, what other pleader has pleaded against me or in favor of that his client, and what the judiciary or judges has spoken during the argument. क्या होता है जब हम कोई आर्गुमेंट कर लेते हैं, जब जजमेंट पास होता है, then whatever the arguments, whatever the case laws we have presented before the court, that is not being written in the judgments. So it was my petition also, it was in my petition, and even before the Supreme Court I had submitted that all the proceedings of the court should be recorded. It should be kept up to the certain periods till the appeal periods is existing limitation के अंडर में, and then only it should be destroyed, so that if sometimes any appeal is being filed on the basis of the recordings, okay, I have pleaded these things and this thing has not been considered by the courts, and whatever the judgment court has to be delivered, that is his discretion as per the law, as per the present circumstances. But at least if I have pleaded something in my favor, in favor of my client, it should be on in the part of the judgments. So that has also become now to the guise and boon and disguise of the COVID. COVID has taught us, and now that is most of the judiciary now implementing online conference system, online argument system, online filing system. So what, as an Indian citizen, I feel proud that some of my presentation or some of my petition which I have submitted before the parliament, the government is considering. I hope slowly, and if it is not in the 75th of the independence, at least at the 100th year of the independence, the legal language of the Indian judiciary or even the court, even the people, it will be in their local language, and mostly in Hindi language, that is our national language, because it is being known by more than 75% people all over the country. एक तमिल भी हिंदी जानते हैं, बोल सकते हैं, एक बंगाली भी हिंदी जानते हैं, बोल सकते हैं. ठीक है, उनके अपने लैंग्वेज स्टेट के है, they want to improve their own language, so that should be there. So that is all for today's my presentation, my submission before you all august luminaries of the law fraternity, and that's all for you. So if any question is there, I am open for the question. Thank you.
Sir, since your topic of discussion is regarding the importance of Hindi in judicial system, I'll keep this session in Hindi. So first of all, बहुत ही अच्छा उपदेश था सर, और मैं वत्सल चौधरी, टीचिंग एसोसिएट स्टारेक्स यूनिवर्सिटी के टीचिंग एसोसिएट के पद पर कार्यरत हूँ यहाँ पे। और आपकी व्यस्तता को देखते हुए मैं इस प्रश्नोत्तर सत्र को बहुत ही छोटा रखने की कोशिश करूंगा। मेरा सिर्फ आपसे एक ही सवाल है कि आपके विचार में भारतीय समाज में क्या नए बदलाव आएंगे अगर उच्च न्यायिक व्यवस्था को हिंदी में चलाया जाए?
देखिए, मैंने अपने संबोधन में कहा है कि हमारी 80% जो पॉपुलेशन है, जो आम जनता है, उनको इंग्लिश नहीं आती है, या तो अपने वो लोकल लैंग्वेज बोलते हैं। ये कहावत है कि हर एक 5 कोस पे भाषा बदल जाती है। हिंदी में भी बहुत चेंज होता है। हम यहाँ पे बोल रहे हैं, हरियाणवी में बोलते हैं, राजस्थान में चले जाएंगे राजस्थानी में बोलते हैं, लेकिन उसका मूल जो भाषा है वो हिंदी से ही प्रेरित है। तो जब हम उच्च न्याय व्यवस्था में जाते हैं और वहाँ पे जो बहस होती है, वहाँ पे जो आम जनता का जो केस होता है, एक वकील इंग्लिश में वो उसको ड्राफ्ट करता है। तो जो आम जनता की ड्राफ्टिंग है, क्या उसका केस है, वो इंग्लिश में पढ़ के उसको बेचारे को समझ नहीं आता कि मेरा कौन सा जमीन का, कौन सा खसरा का, कौन से खतियान का जो हमारा केस हमारे वकील साहब ने पेश किया है। फिर बहस भी इंग्लिश में होती है। उस बेचारे मजदूर को, उस बेचारे छोटे से धनी राम को ये नहीं समझ में आता है कि बहस में क्या कहा गया। वो पीछे रहता है, क्योंकि आप जानते हो जब बहस होता है तो सिर्फ 2 वकील बहस करते हैं। क्लाइंट को बहुत कम बोलने का अवसर मिलता है जब तक कि वकील उसकी तरफ से अनुपस्थित ना हो। तो उसको ये भी पता नहीं होता मेरे तरफ से बहस क्या किया गया इंग्लिश में। और जब जजमेंट आता है तो जो मेरा अपना एक्सपीरियंस है, हो सकता है मैं कुछ जजेस मेरे से नाराज हो जाएंगे कि वो 10 जजमेंट, उसी सिमिलर जजमेंट निकाल के उसको कोट कर लिखते हैं, और बाद में थोड़ा सा एक लाइन होता है, या तो आप फिर से रिप्रेजेंट कीजिए या फिर आपको ये रिलीफ दिया जाता है। तो आम जनता के लिए, जैसे आपने प्रधानमंत्री जी का भाषण सुना कि एक सामाजिक न्याय, भाई ठीक है, बहुत मोटी मोटी लॉ की किताब बन गई है, बहुत सारे लॉज आ गए हैं, लेकिन मेरे ख्याल से 3 जो मूल आधारभूत लॉ है भारत के लिए, वही अपने आप में बहुत है सामाजिक न्याय प्रदान करने के लिए। एक तो संविधान अपने आप में परिपेक्ष है, संपूर्ण है, लेकिन उसको लोगों ने जो कहते हैं ना कि अपने आप को लॉ के ज्यादा समझ रहे हैं, छोटा छोटा लॉ बना के अलग अलग लॉ बना दिया है। दूसरा है आईपीसी जो आपराधिक धारा है, और तीसरा सिविल कोड लॉ। अगर ये 3 को हम अगर मानक मान के चले तो मेरे ख्याल से जितने ये 200-300 जब प्रधानमंत्री जो बोल रहे थे 1800 डिफरेंट लॉज हो गए हैं, अंग्रेजों के टाइम से बने आ रहे हैं, उनकी कोई आवश्यकता नहीं पड़ेगी। आप एक लॉ के खुद वो रहे हो, आप अगर ठीक से पढ़ो तो सीपीसी में, आईपीसी में और सीआरपीसी में अपने आप ही सब कुछ व्याख्या किया गया है। और उसी तरह संविधान को अगर माना जाए तो किसी को किसी प्रकार की न्यायिक व्यवस्था से कोई उनको न तो दुर्गाव होगा, ना ही वो न्यायिक व्यवस्था के विरुद्ध कुछ उनको लगेगा कि हमें न्याय नहीं दिया गया है। तो ये मेरा अपना सोच है एज ए टीचर, एज ए लॉयर, और इसके हिसाब से।
बहुत ही अच्छा उत्तर था सर। अब मैं श्रीमती दिव्या त्यागी जी को धन्यवाद प्रस्ताव के लिए आमंत्रित करता हूं।
Good morning, everyone. Thank you very much, sir. That session was really very knowledgeable. Being a non-law person, I'm strongly agree with your both the points. The first one regarding the language, and the second one recording of the arguments. So I think all law persons who belongs to the this university or the other, they agree with this point. Thank you, sir. Thank you for your time. Thank you very much.
And I am happy to learn that even the Prime Minister has agreed with that. अगर आप उनका वो भाषण सुने जो उन्होंने मुख्यमंत्री और मुख्य न्यायाधीशों के बीच दिया था, तो उन्होंने इसी पॉइंट को एक्सेप्ट किया है। धन्यवाद मैम।
Thank you, everyone. Thank you, sir. Participants, the feedback form is shared in the chat box. Kindly fill out the feedback form before leaving the session. The session will go on for 5 more minutes and then we'll end the session. The feedback form is available on the WhatsApp group as well as on your Gmail. Kindly fill out the feedback forms for your attendance. Thank you.